Okay, Suyash, we are ready to go.
Sure. So, good evening, everyone. My name is Suyashandwar, and I am the host for today's session. And me, on the behalf of the Just Corpus team, I welcome you on the today's topic session, that is jurisdiction on the CCI. So, before dwelling into the discussion, I would just like to give a brief discussion on the Just Corpus team and the speaker today. So Just Corpus is an educational company that is published in 2020, which is compromising of legal professions under a similar umbrella, with an impressive reach of average reaching 600K clicks per month on its website. Just Corpus was inspired by growing needs of law students. As a part of the initiative of Just Corpus has introduced interdisciplinary journal known as Just Corpus Journal Law. Now, turning attention to today's focal point, we are privileged to have Ms. Raveena Kumari Sethia ma'am as a respected speaker. Ma'am is currently working in the competition law field and at Shardul Amarchand Mangaldas firm, New Delhi. She is also visiting faculty in the Jindal Global Law School. Apart from her work, firm and university, she is also associated with a firm, a platform for female legal profession in India, where she worked towards bringing the community closer through Content Drive initiative. She recently co-founded the Apji Vijay Singh and Rani Aruna Kanwar Foundation to work towards animal welfare and uplifting women's children and other marginalized community. She also completed her LLM from University of Cambridge in 2018 as Justice Pratibha M Singh and Cambridge Trust Scholar. While pursuing her LLM, she was offering a training contract with Herbert Trust Scholar, Herbert Smith Freehills, London. Prior to that, she was graduated from Jindal Law School in 2017 with a silver medal in academics as a Savitri Jindal Scholar. She also worked in a competition team with the Trilegal in Mumbai for a brief period of time. So, without further hindrance, I would like to hand over this floor to ma'am. Ma'am, over to you.
Thank you so much for having me, and thank you to everybody who's joined on your Friday evening. We will keep this really short and more topical. So, the topic here for today is jurisdiction of the Competition Commission of India. For those of you who aren't familiar with this subject, competition laws in India aim to regulate or rather oversee the way free markets and regulated markets to some extent as well operate. The idea is to promote customer and market welfare and oversee that dynamics within any space between competitors or between upstream and downstream players are operating in the most fair and natural manner without any market distortions. So with that in mind, we had the Competition Act, which was passed in 2002, and there have been various rounds of amendments to the Act, the most latest being in 2023, which is the biggest and most major amendment to the Act. Several provisions of the amendment have now been notified as recent as last week. Recently, we also have the report of the CDCL, which also recommends ex-ante regulation for big tech players and a separate law to regulate them, which will also be within the aegis of the Competition Commission of India. So competition laws in India are really seeing an upswing, and definitely from the point of view of tech players for sure. Today, we're discussing jurisdiction of the Competition Commission and generally how does competition law sort of interplay when other regulators are involved. So as a broad principle, competition policy suggests that regulators within this field should intervene when there is distortion to free market conditions. So when they see, for example, that a very large company is pricing their products excessively, and this leads to detriment in the market because consumers aren't being able to source products at competitive prices and are being forced to pay these excessive prices because they have no alternative. Or, for example, if certain players come together and they start engaging in bid rigging, so they start deciding beforehand how they're going to bid for various tenders, what prices are going to be quoted, and the outcome is already predetermined. So when you do these type of practices, you deny the market, the consumers, the tendering authority in question, the benefit of having seen how things would have played out if free market conditions without these distortions were involved. So with that policy in mind, the Competition Commission has been empowered to intervene wherever it sees that there is any distortion to competition, irrespective of the industry in question. So there are, as you know, in India, because we are still um, quite a welfare state, there are some industries that are still quite regulated. There are some companies which are public sector undertakings, which still have a lot of market power as a result of statute. So we aren't a completely free market system in that sense, but we have a mix of regulated markets as well as free markets, and all free markets also now have industry specific regulators and regulations for various aspects. So the idea is that the CCI is able to intervene irrespective of the industry or the company in question, as long as it sees that there has been a potential violation of competition laws in India. And this gives it vast powers because it can then therefore tend to overlap in terms of its jurisdiction with other regulators in certain instances as well. And this type of conundrum has come up before courts several number of times, including before the CCI itself. And we have seen various courts take various views. As recently as 2023, there have been two judgments from the Delhi High Court that have barred the CCI's jurisdiction in two different set of circumstances, which is the more topical part that we can get to in a bit. But as a general principle, law applies to any entity which is defined as an enterprise under the Act. The definition of enterprise is very wide, and Section 2 has all the definitions, so you can look at that when you have the time. The way enterprise has been defined under the Act is very wide. It not only includes private players, companies, individuals, it also includes government bodies, it includes departments of government as well. So irrespective of your ownership and who controls you, you still may be considered an enterprise under the Act and still may be within the purview of the Act. So if any enterprise engages in any activity that is defined as anti-competitive under the Act, then such an enterprise will be subject to proceedings and can be therefore penalized under the Act for any anti-competitive behavior. The penalties under the Act are very wide and they're very high. These can be up to 10% of the company's turnover in certain cases, or even 3 times the company's profit. The CCI is also empowered to actually fine individuals in case it finds out that there have been violations where individuals are involved. We see this most often in bid rigging cases or in cartel cases, where there has been activity which is concerted and over a period of time that involves various individuals as well. So broadly, that is the jurisdiction of the CCI. For parties, it's not necessary that they have commercial arrangements with each other or with their distributors or suppliers in writing or in formal ways. Agreements can also be inferred, and your intention to collude can even be inferred through your practices and through other, additional means available. So even if you were entering into an agreement which is by object unlawful under Contract Act, that still doesn't preclude the Competition Act from having jurisdiction within that, and the CCI can still look at it. So that's broadly the way in which this act functions. And the rule of thumb is that everything that has an anti-competitive angle is within the purview and jurisdiction of the CCI, unless and until it can be proven otherwise. I think that's a better way to look at it, because that is the intention of the legislature as well. In terms of jurisdiction, there are several. The first sort of hurdle comes up when entities try to argue that they aren't enterprises under the Act. A lot of time, entities have tried to argue for various reasons that they're either a government department or they perform a mix of economic and social functions, or that they've been established, say, for example, to fulfill an altruistic purpose under the Constitution. And for those reasons, they shouldn't be subject to the Competition Act. In such cases, the CCI has taken various views. For example, we have seen recently there is a case involving the Chartered Accountants Institute, where the Delhi High Court held that the Chartered Accountant Institute has a twofold role. It basically is a regulator in itself because it controls the way chartered accountants are appointed and designated, but it also has an economic function. Every time it needs some activity or some work, it will issue tenders, it will invite participation, it will decide to award these tenders, it will engage in this type of commercial activity as well. Hence, as a whole, you cannot say that this institute is not an enterprise, even though some parts of its functions might be regulatory functions. So the scope in terms of defining enterprise is very wide, and if you have to get away with it, the thresholds are really high. You have to really prove that you don't engage in any economic activity at all, and that what you're doing is primarily, say, for example, for the purposes of defense or for the purposes of, furthering atomic energy or some specific exceptions which are within the act, really. So that's the sort of scope of this. Apart from that, recently we were a part of this case, which was argued on behalf of Coal India. So Coal India went before the Supreme Court and it argued that it should not be considered as, within the subject matter of the Competition Act, because it is a public sector enterprise. It is an enterprise that has been formed to further the goals of Articles 31C, 39B of the Constitution, and therefore it has a special place and protection under the 9th schedule of the Constitution as well. Therefore, all the actions and activities undertaken by Coal India are in furtherance of this objective of the sort of government's decision and Ministry of Coal's decision in terms of distribution of coal, in terms of the customers it's allocated to, in terms of the quantities allocated, etc. So we tried arguing that if you allow the Competition Act to have jurisdiction on entities like Coal India, eventually there will be an overlap and there will be a hurdle that you will face, because certain actions that have been taken by certain actions that the Competition Commission is capable of taking could have drastic effects and impacts on Coal India and its day-to-day activities that could then negatively impact the objectives and goals of the Ministry of Coal or Ministry of Power, and entities that do control its day-to-day functioning. However, the Supreme Court was very clear. They said that the Act has defined enterprise very broadly, and Coal India, because it engages in economic activities, because it is engaged in distributing coal, entering into contracts, everything, you cannot say that it is not an enterprise. And if the legislature's intention was to exclude Coal India from the jurisdiction or purview of the Act, then it would have explicitly made an exception for it, and that is not the case. So this is a judgment from the Supreme Court of June 2023. It's also the only Supreme Court judgment from last year on the issue of jurisdiction to some extent, but largely on any competition issue. So I would really recommend that you read it and proceed with that. But the CCI has grappled with other instances as well, where it has had to decide whether it has jurisdiction or not. Sorry, just give me 1 second. Sorry. So there have been other issues as well that they have grappled with. So for example, a lot of times parties come and argue that the issues that we have are purely contractual in nature. These don't actually involve competition issues at all. And therefore, we don't think the Competition Act is the correct legislation for this dispute, and that we will go to civil courts for our remedy. In such cases, one, for example, that was against ONGC, the CCI very clearly said that it is not barred from looking into contracts. It's not barred from looking into contractual clauses, so long as those clauses do have an element of anti-competitiveness in them. So one example is, if there are one-sided clauses in agreements, then such clauses can also be considered by the CCI to check whether they are anti-competitive or not. You cannot say that, oh, this is an agreement, both parties have signed this agreement, so only a civil court or an arbitrator would have jurisdiction. because the nature of this clause is such that it may have been agreed to because one party had significant market power and bargaining power over the other party. It becomes a concern for the CCI to check and to see whether such a clause could actually cause any harm to competition. So as a result of issues like this, the CCI can look at contractual clauses as well. Now, whether a contractual clause in a particular case does amount to a competition issue or not is a case by case determination, right? There could be certain instances where, say, for example, you have an issue in terms of um, quality checking or compensation awarded to you, or say you've ordered food on Zomato or Swiggy and you want a refund of 50 rupees or 100 rupees. There can be certain clauses like that which talk about refunds or talk about very specific issues. Unless and until you can prove that something like that could harm competition in the market at large, the CCI is not likely to intervene in such cases because they look like disputes between me and individual and then the food ordering platform, right? They don't really look like issues that could harm the market at large otherwise. So you have to prove in each instance why is that contractual clause detrimental to competition, and you have to make a positive case to the CCI to show them that this actually is having or is capable of having a negative impact. So this is important to keep in mind because these are usually the first two thresholds that parties use to oust the CCI's jurisdiction. They always try to argue that the dispute is commercial. They always, if possible, try to also use the enterprise point to say that they aren't enterprises where it's applicable. So these are the most common to keep in mind, especially if you're ever reading a case and this comes up, or if you ever decide to practice in the future, that, these are going to be your most common go-tos. Apart from this, we actually see and we have seen recently a lot of discussion from the CCI and from high courts and the Supreme Court around the CCI's jurisdiction when there is another regulator involved. So the Competition Act under Section 60 to 62 gives the Competition Commission, there's like a non-obstante clause, and the Competition Commission is given jurisdiction to look into a wide number of cases, irrespective of the sector involved, irrespective of the specialist regulator involved in that case as well. So these sections are highly, highly empowering, and they actually provide for the fact that the Competition Act must be read in conjunction with other statutes and not that you read the Competition Act in silos or in isolation with other statutes. So you have to read all laws applicable harmoniously and then see which law should apply. The normal rules of statutory interpretation also do apply to some extent. So, for example, a later law precedes an earlier law. However, you also see the nature, object, and purpose of a particular statute to determine whether or not it's actually at loggerheads with an existing law or whether it can be seen in terms of a complement to one another. So these issues have grappled the CCI, High Courts, and the Supreme Court quite often because, as I started in this lecture, we aren't in a completely free market system. We are in a market system where there are several micro regulators for several aspects in various types of industries. So you have chartered accountants, they are regulated in their own way. If you practice patents, you know that there is a patent act and there is an authority in its own way. You know that there is also the RBI that regulates payment gateways, and they have a Payment and Settlement Systems Act as well, which has its own redressal mechanism. For consumers, you have the Consumer Protection Act as well. So there are various micro regulators and regulations around which actually can be seen in terms of dispute resolution mechanisms for specific issues within those specific laws. However, the question is, does having something like that oust the jurisdiction of the CCI? Can you say just because there is a Patents Act, does that mean that the Competition Act has no role to play when it comes to any issue surrounding patents? The answer to that has been given by the Delhi High Court recently. and it is now pending before the Supreme Court. I will come to it, but before that, we have the leading sort of case on this point right now is still Bharti Airtel. This is a Supreme Court judgment, and in this judgment, the tussle between the telecom regulator and the CCI was considered. There were certain issues which both the CCI and the telecom regulator were looking at simultaneously, and they were overlapping in their nature to some extent. So the Supreme Court held that if it is an issue and the subject matter of that issue is at the core of the telecom regulator's authority and jurisdiction, then the telecom regulator will have precedence and they should decide on that issue first. If the same issue or the decision of that issue impacts the competition case, if there exists a competition case even after that, and that particular decision impacts the competition case, then depending on the decision of the telecom regulator, the CCI will then have jurisdiction to decide. So essentially, the idea is that if we have a dispute on a license that I have granted, is something that I have sub-licensed to you, right? But the license itself has come under TRI. It's been something that has been approved by TRI. Then the issue of sub-license cannot be decided, or the competitiveness or non-competitiveness of that sub-license cannot be decided until and unless the main issue on licensing itself is clear, right? If I never had the license from TRI to begin with, I couldn't have sub-licensed it further. So therefore, the first issue needs to be decided. And thereafter, once that issue is decided and it is determined that, yes, this was the right license, it was for this purpose and that purpose, if after that the competition case still holds, then yes, parties are free to approach the CCI, update them of the proceedings, and take care of the competition case as it were to go. Now, these two most academic scholars and practitioners has consistently been looked at as the more logical approach, because it does make sense, right? If both regulators are looking simultaneously, they might come up with various diverse points of view. And then that will cause a disharmony when you read laws together, when you read this precedent together. So therefore, when one has decided and the second one takes the baton from there, you will have some harmony in terms of the interpretation and the jurisdiction. So that's been the sort of leading judgment on this point. However, more recently, as I told you, this principle has been muddled a little bit. So we've had two diverse cases last year from the Delhi High Court. One has been by Ericsson and Monsanto, and the other one has been by the Chartered Accountants Institute. So in the Ericsson and Monsanto case, essentially, the CCI had started proceedings against both of these companies regarding certain patents that they had. And they filed a writ before the Delhi High Court saying that the CCI doesn't have jurisdiction. The issues in this case fall squarely within the Patents Act. And the Patents Act is a complete code in itself. Therefore, the CCI as an external regulator doesn't need to step in, because here you have a patents authority, which is the specialized regulator. The Delhi High Court in a division bench agreed with these submissions, and they said that yes, in such a case, the CCI will have no jurisdiction, and if there is any anti-competitive conduct that arises from licensing of our IPR, then that needs to be examined under the Patent Act. And they've said very clearly that there is a Chapter 16 of the Patents Act that has all provisions which are a solve for such issues, and that chapter is good enough to take care of these things. By contrast, we also have another case which is under the Chartered Accountants Institute. In that case, again, it was before the CCI, and it was argued that there were certain directives from the Chartered Accountants Institute that were guidelines for potential CAs, and these guidelines were really strict and strenuous in nature, and therefore they were actually anti-competitive because they were restricting the number of CAs who would be eligible. This was then there was a writ filed against this sort of provision before the Delhi High Court again. Last year, the Delhi High Court decided and said that while the Chartered Accountants Institute is an enterprise, the issue that's before them is not a competition issue. The issue that people are having is with respect to their policies and the way that they frame guidelines. And this is something which is completely a policy issue. It's more of a public interest issue, but not really an anti-competitive thing that they're doing. They're not doing it to exclude a competitor or to enter into agreements and to market share or do anything illegal really under the act. But they are doing this to make sure that there is quality control within this ecosystem and within the profession. So under those grounds, they said that the CCI doesn't have jurisdiction. But the contrast in the two cases is that they were decided on completely different points. In the chartered accounts case, it was easy to say that the CCI had no jurisdiction because there was no real competition concern. But in Monsanto, it may or may not be the case, right? There are certain instances where patents can be used to exclude competitors. If you don't license your patents at free and fair terms, especially if those patents are SEPs or essential or required for other players to compete on the market, then you are by that logic excluding a large part of competitors from even entering a market. And you're therefore excluding your competition, which will give you eventually the power to charge whatever you want at that price, at whatever price you want for that particular product, and use your patent in ways to make sure that not even just competitors, but players at the upstream and downstream are also dependent on you. So it remains to be seen whether the Monsanto decision of the Delhi High Court will really lay down the law in terms of jurisprudence and will really lay down the law in terms of the way we move forward, or will the Supreme Court go back to Bharti Airtel and come up with a similar sort of line of discussion where they might say that the Patents Act should be your first recourse to decide any core patent issues and core issues regarding whether the patent is valid or not. And then once that's been decided, whether the case still remains and is alive for the CCI to decide on competition aspects of it. So this is something that you can watch. These proceedings will start in the Supreme Court, and we should get a decision hopefully by this year. So that will be something which is important for everyone across the board to look at and really consider. Lastly, in terms of jurisdiction, we've also had the Google case to some extent. So Google has been, there have been writs filed by various, apps and third parties against Google in the Madras High Court, for example, which was against Google's billing system and a certain commission it was charging. And the Madras High Court also very recently, this year, in fact, itself has said that look, the issues that have been raised are similar to issues that were raised in a similar case before the CCI, and that the CCI would be the right body to adjudicate on these issues. It wouldn't be the High Court. It wouldn't really be the place of the High Court to decide on the competitiveness of Google's charges and Google's billing system, etc. So they said that this is not really going to be something that the High Court or Civil Court can look at. There is the CCI, and you also have the Payments and Settlement Systems Act, where the RBI has a role to play as well, and those rules and regulations will also apply as applicable. They also clearly said that Section 61 of the Competition Act, read with 62 of the Competition Act, does not bar jurisdiction of civil courts, but you have to read things harmoniously. So where the CCI has power to do something, it can do it. However, where it doesn't have power to do certain things like grant compensation, those are things that you have to go to the NCLAT, for example, or civil courts, for example, and you have to basically look at the forum to decide the legal issue and then look at the right forum in terms of your remedies as well. So largely, I think in terms of jurisdiction, we have set principles, which is that if you are an enterprise and you're not barred and you do engage in economic conduct and you do engage in conduct which has been specified under the Act, then you are very much within the CCI's purview. If you are in a situation where you are being regulated by various bodies within your industry, the CCI will still largely have jurisdiction, but you will have to see depending on the nature of the dispute and the nature of the issue. If there is something where both parties might have overlapping jurisdiction, it needs to be seen which of those parties should first decide the issue in a logical manner for the other party to take recourse as well. And thirdly, if there are issues which involve contractual disputes or contractual clauses that are allegedly anti-competitive, then those need to be tested clause by clause and situation by situation. There is no sort of blanket rule in terms of what might be within the CCI's purview in those cases and what might not be. But largely, if there is a clause in an agreement which another party has probably acquiesced to because they lack market power and bargaining power against a dominant or a big party, then such a clause might be within the purview of the CCI. But if it's something which is minor, if it's a clause which is between parties who had bargaining power, which really doesn't consider the market at large, but purely consider certain specific concerns between the relationship between those two players, then maybe such a clause doesn't really fall within the purview of the Act. So those are the broad principles on jurisdiction. I didn't want to make this very long and boring so that we lose focus. And I wanted to focus more on the recent cases rather than old cases repeating the same point. So that's it from me. If you have any questions, please feel free. I think we have another 5 minutes and then we can close.
Am I audible?
Yes.
Thank you, ma'am, for providing this insightful information. I can make sure that it was not a boring lecture. It was like a 2 hour lecture I have attended in 15 to 20 minutes.
Mhm.
So, ma'am, I have some written questions from some participants.
Yes.
First question is, shall CCI prohibit anti-competitive agreements?
Yes,
It should.
it does. It's in the law. Section 3 of the Competition Act prohibits anti-competitive agreements.
Okay, ma'am. Moving on to next question. Ma'am, it is about the jurisdiction of the CCI. Like, does the CCI jurisdiction fall outside the territory of India as well?
So the CCI can consider technically conduct which is outside, which has an impact in India, but they cannot, for example, order remedies that are applicable outside India's jurisdiction. In several cases as well, we try to define the markets in which players are active or in which the CCI can consider conduct. And the CCI has largely always restricted markets to India wide, saying that we cannot enforce our jurisdiction outside. But if there is conduct outside which has some impact in India, then they can definitely consider that conduct in terms of seeing the effects within our jurisdiction.
Ma'am, there is one question related to this thing only. How does the CCI handle cases involving the cross-border or international aspects?
So if there are cross-border cases that are enforcement cases like abuse of dominance or anti-competitive agreements, and there are other jurisdictions looking at it as well, then the CCI has the ability to, consider the developments in those jurisdictions and decide, its approach. However, that's not necessary. The CCI is not required to liaison with agencies and other jurisdictions. It can decide the case on its own, and it can decide the case based on facts specific to India. When it comes to merger control cases, more often than not, when there are global mergers, the CCI does have the ability to reach out to regulators and other jurisdictions. And usually it does ask the parties to keep it posted regarding developments in other jurisdictions and whether that transaction has been approved conditionally or unconditionally in other places as well, so that it can take that feedback into account. But that said, in either case, the CCI is deciding something from the context of India and in the context of players and markets in India. So it need not really bother about cross-border developments unless and until they will have some impact in the way that they assess the Indian scenario.
Okay, ma'am. The next question is, can you explain the process by which a party can approach the CCI with complaint or concern regarding anti-competitive behavior?
Yes. So Section 19 of the Act allows anybody who is, it could be a student, it could be an individual, a company, a competitor, a supplier, anybody aggrieved by any potential anti-competitive conduct to file what we call an information, which is like a complaint before the CCI. There is a format for the information available. And usually what people do is they engage lawyers to come and help them file these informations and substantiate their allegations. Once the information has been filed, then it is on the CCI to consider that information and decide whether or not it wants to proceed towards an investigation or close the matter upfront.
Okay, ma'am. Now it's time for the final closing. Let's move to the votes of thanks. Closing, we extend heartfelt gratitude to Ms. Raveena ma'am for accepting our invitation and delivering such informations for the session. We trust that the audience found it both interesting and knowledgeable. Thank you, ma'am, once again, and we eagerly anticipate the opportunity to host you again and listen more and more cases in the summaries that you tell in the today's session.